Ladies and gentlemen, you've been sitting for about an hour now, so if you want to get, well, close to 2 hours now, so you can stand up, move around, stretch out a little bit. As you do, Mr. Mullins is going to distribute to you the jury instructions. In the 14 years or so that I've been a judge, it's been my experience that different people absorb different information in different ways. I'm going to read you the instructions of law in this case. You are also going to have a printed version of what I say. If you are one of these people that likes to follow along and read along, then you can follow and read along. If you are one of these people that would prefer just to listen, you can do that as well. The one thing that you can't do is sort of flip ahead and see what is coming next. You will have these instructions with you in the jury room, and sometimes I have a tendency to ad-lib, which means I will leave my prepared remarks. I will try to let you know when that is, and also when I return. So if everybody could be seated, please. Does everybody have a copy? Yes? All right. Everybody have a copy? We have an extra one? Okay. All right, you can just hold on to that. Wait, does somebody not have one? Raise your hand if you do not have a copy of the instructions. Okay, no hands. All right, it starts where it says, General members of the jury, you have heard the evidence and the arguments of counsel. It is my duty to instruct you on the law. The court and the jury have separate functions. You decide the disputed facts, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and apply the law as I give it to you. You are not permitted to change the law, nor to apply your own idea of what you think the law is or ought to be. The case before you began with the filing of the indictment. The indictment informs Ms. Richardson that she has been charged with a crime. You may not consider the fact that it was filed for any purpose. Ms. Richardson has entered a plea of not guilty, which means that you are not to assume that any of the facts alleged in the indictment are true. A plea of not guilty is a denial of the charge and puts at issue all the essential elements charged in the indictment. The defendant is presumed to be innocent unless guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say that you are firmly convinced of the truth of the charge. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Evidence is all the testimony received from the witnesses and the exhibits admitted during the trial. You may consider both direct and circumstantial evidence. You must decide from all the direct and circumstantial evidence taken together whether the state has proven all the elements beyond a reasonable doubt. Direct evidence is the testimony given by a witness who has seen or heard the facts about which the witness testified. It includes the exhibits admitted during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts that naturally and logically flow according to the common experience of people. I'm going to leave my script here to give you an example. Let's say that it was your job as jurors to determine whether or not it had rained outside. If we brought a witness in here and they said, I saw it raining, that is direct evidence that it had rained. But if we had a witness who came in here and said, I didn't actually see it raining, but it was dry when I was outside, then I was inside, I heard the little pitter-patter on the roof. I went back outside, I saw puddles on the ground, water on the cars. That is indirect and circumstantial evidence from which you can conclude that it had rained. Returning here, it says to infer or to make an inference is to reach a reasonable conclusion of fact that you may but are not required to make from other facts you find have been established by direct evidence. You may infer a fact or reach a conclusion only from other facts that have been proved by direct evidence. You may not draw an inference based entirely upon another inference unsupported by any additional fact or another inference from other facts. An inference which is based in part upon another inference and in part upon facts is a parallel inference, and if reasonable is an acceptable conclusion. Whether or not an inference is made rests entirely with you. The evidence does not include the indictment or the statements of the attorneys. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. The attorneys may use words or phrases or descriptions which support their version of the facts. For example, the prosecutor may refer to the individual who is alleged to be the victim in this case as the victim, or the events surrounding these allegations as a crime. It is up to you, based on the facts and the law the court provides you, to determine if there is a victim, a crime, or whether the facts support these words, phrases, or descriptions. The evidence does not include any statements that were stricken by the court or that you were instructed to disregard. You must not speculate as to why an objection was sustained to any question or what the answer to that question might have been, because these are questions of law that rest solely with the court. Likewise, you must not draw an inference or speculate on the truth of any suggestion included in a question that was not answered. These statements must be treated as though you never heard them. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the believability of witnesses, and to do this, you will use the tests of truthfulness that you use in your daily lives. These tests may include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, and the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use the criteria you believe to be the most appropriate and assign to each witness's testimony such weight as you think proper. You are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the witness's testimony. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. It is not necessary that the defendant take the witness stand in her own defense. She has a constitutional right not to testify. The fact that Ms. Richardson did not testify must not be considered by you for any purpose. Testimony has been admitted, indicating that the defendant may have attempted to conceal a crime. You are instructed that these acts alone do not raise a presumption of guilt, but may tend to indicate the defendant's awareness of guilt. If you find the facts do not support the defendant's actions indicate an awareness of guilt, or if you find that some other motive prompted the defendant's conduct, or if you are unable to decide what the defendant's motivation was, then you should not consider this evidence for any purpose. However, if you find that the facts support the defendant engaged in such conduct, and if you decide the facts support the defendant engaged in this conduct, and if you decide the defendant was motivated by an awareness of guilt, you may but are not required to consider that evidence in deciding whether the defendant is guilty of the crimes charged. You alone will determine what weight, if any, to give this evidence. You have heard some testimony concerning such things as the defendant engaging in premarital sex, having an eating disorder, thinking about abortion, or making an internet search. This evidence is not permitted to establish the character of the defendant or to prove that she may have acted in conformity with that character on a particular occasion. I'm allowing it for the limited purpose of the mental state and or knowledge of the defendant, and you may not consider this evidence for any other purpose. If you find this evidence is not material to the defendant's state of mind or knowledge, then you are instructed to disregard it. Generally, a witness may not express an opinion. However, someone who follows a profession or special line of work may express his opinion because of his education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide you to help at a just verdict. Questions may have been asked to an expert which were permitted to assume certain facts were true and to give an opinion based on that assumption. You must determine whether or not the assumed facts upon which the expert based the opinion are true. If any expert assumed a fact that was not established, you will determine what effect this has upon the opinion of the expert. With regard to the psychological testimony you heard in the case, I allowed this testimony for the limited purpose of evaluating Ms. Richards' behavior during the police interviews and what use, if any, you will make of these statements. It was not permitted, and you are not allowed to use it to suggest that she did or did not have the mental capacity to commit these offenses, or as to the evidence of her mental state at the time of the allegations. As to other witnesses, Upon you alone rests the duty of deciding what weight should be given to the testimony of the expert, and in determining its weight, you may take into consideration their skill, experience, knowledge, veracity, familiarity with the facts, and the usual rules of testing credibility and determining the weight to be given to testimony. A number of exhibits and testimony relating to them have been introduced. You may consider whether the exhibits are the same objects and in the same condition as when they were originally taken. You will determine what weight, if any, the exhibit should receive in light of all the evidence. You will have with you in the jury room the recorded exhibits and a computer that does not have internet access with which to play these recordings if you wish. If you are unable to play the audio on the computer and wish to hear it, please contact Mr. Mullins. He will help you with any technical aspects. You were provided with transcripts of one or more of the recordings to help you follow along, but as I told you before, the audio and the video are evidence, the transcripts are not. You will not have a copy of the transcript with you in the jury room. It is not necessary the state of Ohio prove that the offense was committed on the exact day as charged. It is sufficient to prove that the offense took place on a date reasonably near the dates claimed. The defendant is charged in count 1 with aggravated murder. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about May 6, 2017 to May 7, 2017, and in Warren County, Ohio, the defendant purposely caused the death of another who was under the age of 13. Purpose to cause the death of another is an essential element of the crime of aggravated murder. A person acts purposely when it is that person's specific intent to cause a certain result or engage in conduct of a certain nature. It must be established in this case, at the time in question, there was present in the mind of the defendant a specific intention to cause the death of another. Purpose is a decision of the mind to do an act with a conscious intent to produce a specific result or engage in specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person unless he or she expresses it to others or indicates it by his or her conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all the other facts and circumstances in evidence. Proof of motive is not required. The state charges that the act or failure to act of the defendant caused the death of the alleged victim. Cause is an essential element of the offense. Cause is an act or failure to act which, in the natural and continuous sequence, directly produces the death and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that flow in the ordinary course of events from the act or failure to act. With respect to the charges of aggravated murder, involuntary manslaughter, and child endangering, the defendant cannot be found guilty of any criminal behavior with respect to her unborn child while she is pregnant. As I told you in the initial voir dire, the most frequent example of this is, which is not an allegation in this case, this is where an expectant mother takes illegal drugs and the child is born addicted to those drugs or dies as a result of that drug usage. The mother in that example cannot be prosecuted for endangering or killing her unborn child. Likewise, it is not a crime for the defendant not to obtain prenatal care or for her to do things while pregnant that may be harmful or injure her unborn child. In order to find the defendant guilty of aggravated murder, involuntary manslaughter, and/or child endangering, the state of Ohio must prove beyond a reasonable doubt that the child alleged to be the victim in this case was born alive. The defendant is charged in count 3 with endangering children. I'm instructing you on count 3 before count 2 because of the way that they are interrelated. But they are still separate counts. Before you can find the defendant guilty of count 3, you must find beyond a reasonable doubt that on or about May 6 to May 7, 2017, and in Warren County, Ohio, the defendant, who was the parent of a child under the age of 18, recklessly created a substantial risk of health or safety of her child by violating a duty of care, protection, or support. A person acts recklessly when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that his or her conduct is likely to cause a certain result or be of a certain nature. A person is reckless with respect to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. Substantial risk means strong possibility as contrasted to a remote or significant possibility that a certain result may occur or that certain circumstances may exist. If you find the defendant guilty of child endangerment, it is your duty to deliberate further and decide if the defendant's actions resulted in serious physical harm to the alleged victim. If you find the defendant not guilty of child endangerment, you do not have to consider whether or not physical harm occurred. Serious physical harm means any physical harm that carries with it substantial risk of death. Physical harm means any injury, illness, or other physiological impairment, regardless of its gravity or duration. The defendant is charged in count 2 with involuntary manslaughter. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about May 6th to May 7th, 2017, and in Warren County, Ohio, the defendant caused the death of another as a proximate result of committing the crime of child endangering. I have already given you the definitions of cause, endangering children, for you, and you will use those definitions for count 2. You cannot find the defendant guilty of involuntary manslaughter, count 2, without finding her guilty of endangering children, count 3. But you may find the defendant guilty of endangering children without finding her guilty of involuntary manslaughter. Count 4, tampering with evidence, has been resolved, so therefore there is no further consideration necessary by you for this charge. The defendant is charged in count 5 with abuse of a corpse. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about May 6th, 2017 to July 14th, 2017, and in Warren County, Ohio, the defendant recklessly treated a human corpse in a way that would outrage reasonable community sensibilities without being authorized by law to do so. Authorized by law or our county coroner or designated members of the staff, physicians, surgeons, accredited medical students, embalmers certified to remove human organs for transplant purposes, persons authorized to remove certain human organs by consent of the deceased according to law, and all other persons acting under authority of law. Recklessly has already been defined for you. There may be one or more causes of an event. However, if the defendant's act or failure to act was one cause, then the existence of other causes is not a defense. If you find the state of Ohio proved beyond a reasonable doubt all the essential elements of one or more of the offenses charged in the separate counts in your indictment, then your verdict must be guilty as to such offense or offenses according to your findings. If you find the state of Ohio failed to prove beyond a reasonable doubt any one or more of the essential elements of the offenses charged in the separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your, and it should say, findings in there. The charges set forth in each count of the indictment constitute a separate and distinct matter, except as to the count of involuntary manslaughter, where I already provide you a specific instruction on this point. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged. Except for those terms specifically defined in these instructions, you will use the usual, ordinary, and customary meaning for those terms. The court has instructed you on all the law necessary for your deliberations. I will now instruct you on how to conduct your deliberations and how to prepare the verdict forms. You will have with you in the jury room the following verdict forms. I know you can't see them from there, but they look like this. They say, State of Ohio versus Brooke Skylar Richardson. This is the verdict form number 1 for aggravated murder. We, the jury, in the above captioned case, find the defendant, Brooke Skylar Richardson, and then there are 2 alternatives, guilty or not guilty. Circle the one that matches your verdict, scratch out the one that does not, of the offense of aggravated murder. Then there is a place for all 12 of you to sign. Likewise, count 2 says, we, the jury, in the above captioned case, find the defendant, Brooke Skylar Richardson, either guilty or not guilty of the offense of involuntary manslaughter. Verdict form 3, we, the jury, in the above captioned case, find the defendant, Brooke Skylar Richardson, again saying guilty or not guilty of child endangerment. This has an additional finding. If you find the defendant guilty, where it says we find the defendant did or did not cause serious physical harm to the alleged victim. And finally, the abuse of a corpse. We, the jury, in the above captioned case, find the defendant, Brooke Skylar Richardson, again guilty or not guilty of the offense of abuse of a corpse. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide the disputed questions of fact, to apply the instructions of law to your findings, and render your verdict accordingly. Your duty as jurors is to arrive at a just verdict. Consider all of the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that both the state of Ohio and Ms. Richardson will feel their case was fairly and impartially tried. If during the course of the trial I said or did anything that you consider to be an indication of my facts or my view on the facts, you are instructed to disregard it. Because this is a criminal case, it is necessary that you have a unanimous verdict. That means all 12 of you must agree in order to bring a verdict back into this courtroom. You may not discuss or consider the subject of punishment. Your duty is confined by law to deciding whether the defendant is guilty or not guilty of the offense. In the event you make a finding of guilty, the duty to decide punishment is placed by law upon the court. When you go into the jury room, the first function will be to select one of your number to serve as a foreperson. The person that you select to preside over your deliberations does not have any greater power, nor does this person's vote have any more importance than the others. The foreperson serves the purpose of helping you conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. The foreperson also has the additional duties of making sure the verdict forms are filled out properly and to make sure that the blinds are closed during deliberations. Your initial conduct upon commencing deliberations is important. It is not wise to immediately express a determination or to insist upon a certain verdict, because having so expressed yourself, your sense of pride might be aroused, and you may be hesitant to give up your position if it is shown that it is not correct. Consult with one another in the jury room and deliberate with a view of reaching an agreement if you can do so without disturbing your own individual judgment. Each of you must decide this case for yourself. You should do so, however, only after a discussion of the case with the other jurors. Do not hesitate to change an opinion if you're convinced that it is wrong. But you should not surrender your considered opinion concerning the weight of the evidence to be congenial or to reach a verdict solely on the opinions of the other jurors. It may be difficult for you to remember all the evidence or the law. If you disagree as to the evidence, you should try to resolve the issue based on the collective memories of the jury. If you disagree about the law, refer to the written jury instructions, which you will have with you in the jury room. If you are unable to resolve the issue, the court may, under certain limited circumstances, furnish this information. If you have a question, it should be reduced to writing so that there is no misunderstanding as what you request. Then deliver the question to the bailiff, who will submit it to the court. Do not include the status of your deliberations in any questions that you might submit. Ms. Potthoff, Ms. Bledsoe, and Mr. Allen, the alternates are not permitted to participate in jury deliberations unless one or more of the jurors is not able to complete their service. Thankfully, this has not happened. But I'm going to retain each of you as an alternate juror in the case. That means that you are still on the clock. Mr. Mullins is going to get your contact information and will get in touch with you if we need you to return. If not, you will be discharged. You are still bound by all the previous instructions. Do not discuss the case with anyone or permit anyone to discuss it with you. Do not disclose to anyone how you would have voted. Do not view any media coverage, social media, or other information about the case. When the case is over, Mr. Mullins will advise you that a verdict has been reached and you will be discharged from the instructions. I believe that this method is preferable to squirreling you away in one of the rooms here in the courthouse, but you need to make sure that you are available in case we have to call you back into service. We have only a few more minutes of instructions, then Mr. Mullins will see you out while the jury is getting settled. On behalf of the public, the parties, the court expresses appreciation for your services in performing this important public function. After your verdict is returned and your jury service is complete, you may discuss this case with anyone, but you are not required to do so. Whether you discuss the case with counsel, with the press, or anyone else after you discharge is a matter of your own free choice. The court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of these records, including the verdict, and return them to the courtroom. Until your verdict is announced in open court, you are not to disclose to anyone the status of your deliberations or the nature of your verdict. Mr. Mullins is going to collect your cell phones, smartphones. I don't think anybody has pagers anymore. Keep them during the deliberation process. If there is a pressing need to contact home during the deliberations, please let him know, and we will work something out. Does counsel desire any further instruction at this time? All right. After you retire and select the foreperson, when all 12, I repeat, all 12 of you have agreed upon a verdict, you will sign the verdict in ink and advise the bailiff. He will be then returned to the courtroom. Make sure that you do not begin deliberating until all 12 of you are in the jury room and the door is closed and the blinds are down. You can take the jury out. Debbie, here are the forms. Ladies and gentlemen, while they're seeing the jury out, go ahead and start reviewing the exhibits. I'll be back in just a second. We're in recess.